And hi, everyone. Thank you for being here today. And today is game day, so go Canucks, go for all you
Yes.
Canucks fans out there. Today, Anna has already kindly done the land acknowledgements for us, and we will move right along. So my name is Arvin Cahigas, and I am part of the Consultation and Education Services team at WorkSafe BC. Today, I will be discussing two changes that are highly relevant to both workers and employers of BC. We will discuss changes to the Workers' Compensation Act and how this applies to employers and workers on new and existing claims. The primary focus of this webinar will be on the overview of the new duty to cooperate and duty to maintain employment obligations. Now, the purpose of the new legislation, many employers recognize the importance of return to work and are already engaged in effective practices. These legislation formalizes these obligations and reinforces the value of return to work and promotes positive outcomes for workers. Number one, the new legislation provides a legal framework for supporting an injured worker's return to or continuation of work. This amendment establishes a duty for workers and employers to cooperate with each other and WorkSafe BC to support the return to work to return the worker to their pre-injury employment or where this is not possible to other suitable work. This amendment establishes a duty for some employers to maintain the injured worker's employment and to make necessary changes to the work or workplace short of undue hardship. And the new legislation includes financial consequences for failing to either the worker or employer for failing to comply with these obligations under the Act. And the new legislation is intended to achieve better return to work outcomes for workers, support more productive workplaces, and lower workers' compensation costs for employers. Now, the guiding principle with this legislation is claims are handled more effectively between the worker and employer, and the worker and employer are best suited to facilitate a return to work outside of WorkSafe BC intervention. Now, let's talk about the first duty, the duty to cooperate. This duty adds a legal duty for workers and employers to cooperate in the worker's early and safe return to work or continuation of work. So to reiterate, this legal duty applies to both workers and employers. Both workers and employers have matching obligations to cooperate with each other following an injury or illness. Now, there are three elements that form this duty. The first one is contact. Contact must be made at the earliest moment practicable by both parties. The second is suitable work. Both parties must help each other in identifying suitable work. And the third element is agreement on the suitable work. Firstly, the employer must make the suitable work available. And secondly, the worker must not unreasonably refuse the suitable work offer. Now, WorkSafe BC is here to help intervene when necessary, but as I mentioned before, the guiding principle is you don't wait for WorkSafe BC. This is best facilitated between the worker and the employer. And these elements generally happen on the day of or shortly following the injury or illness. Now, a question, what happens if these obligations are breached? That I will discuss later in the presentation. Now, building on our understanding of the duty to cooperate, let's explore in detail the when, how, and under what circumstances the obligations apply. So what claims are impacted? Well, the duty to cooperate applies to all accepted claims where the worker is disabled from earning full wages. And when does the duty to cooperate start? It starts from the date of the worker's injury, date of psychological change, or date of disablement. What is the duration of these obligations? The duty to cooperate begins from the date of the worker's injury and continues throughout the entire life of the claim, including situations where a claim is reopened and where the employment relationship has not been severed with the pre-injury employer. Having said that, even in situations where the employment relationship between the worker and the pre-injury employer comes to an end, the workers' duty to cooperate with other injury employers and WorkSafe BC continues. When does the duty to cooperate apply? Well, essentially, it applies to all wage loss claims with a date of injury on or after January 1st, 2022, so about 2 years ago, and all decisions and actions after January 1st of this year. The legislation itself is not retroactive, but it does allow existing claims to transition to the new legislation. And what about exceptions? The duty to cooperate doesn't apply to healthcare only claims or to preliminary determinations where we are providing financial relief to workers while gathering additional evidence to make a decision on the claim. Now, I've taken the liberty, we have done a number of Bill 41 presentations throughout the province, and there are a number of common questions. And one of those common questions is, do I need medical approval to offer suitable work? Now, I'll leave you a few moments to think on that question. Do you need medical approval to offer suitable work? Now, the answer to that question is WorkSafe BC does not require medical approval in order for a person to be offered or accept suitable work. We require medical to determine acceptance of a claim and entitlement to benefits, but WorkSafe BC does not require medical clearance for someone to return to or participate in suitable work. The next obligation, the duty to maintain employment. Now, this adds a legal duty for employers to maintain employment of an injured worker. And again, as with the previous duty, there are 3 elements contained within this duty. The first one is functional abilities. Firstly, the employer must offer suitable work that matches the worker's functional abilities. And secondly, the worker must update the employer on their functional abilities. Now, if you think about this in comparison to the duty to cooperate, this comes with the communication piece. And that is one aspect within communication that the worker and employer should have in their discussion. The second element under this duty is accommodation. The employer must accommodate the worker to the point of undue hardship. The worker must participate in the worker accommodation, meaning they cannot unreasonably refuse. And the third element under the duty to maintain employment is termination. If a worker is terminated within 6 months of returning to work to either pre-injury, alternative, or suitable work, the employer is presumed to have failed in its duty to maintain employment unless the employer can establish on a balance of probabilities that the termination was not related to the worker's injury. And the worker should request this type of determination within 3 months of the termination of employment. And again, WorkSafe BC is here to intervene when necessary. Now, in addition to some of these elements, there is a return to work hierarchy and how the duty to maintain employment applies. If the worker is fit to perform essential duties of the pre-injury work, the employer has the obligation to return the worker to their pre-injury work or to alternative work that is comparable in terms of job demands and wages. If the worker is fit to work, but not fit to do essential duties of pre-injury or alternative work, the employer must offer the first suitable work that becomes available. The employer is required to make changes to the workplace to accommodate the injured worker to the point of undue hardship. Now, undue hardship essentially means when accommodating a worker becomes too difficult, unsafe, or costly for the employer. Again, as in the previous duty, for the duty to maintain employment, there are some criteria for when it applies. So duty to maintain employment applies to all accepted claims where employers and workers meet the eligibility criteria and where the worker is disabled from earning full wages. So firstly, the eligibility criteria, what is it? So firstly, if employer regularly employs 20 or more workers as of the date of injury, and if that worker must have worked for the worker on a full or part-time basis continuously for 12 months prior to the date of injury. Now, once this eligibility criteria has been met, the obligations start from the date of the worker's injury, date of psychological change, or date of disablement. And this duty applies to all wage loss claims with a date of injury on or after July 1st, 2023, so last year, and all decisions after January 1st, 2024. And with regards to duration, as long as the employment relationship exists, the employer has an ongoing obligation to make changes in the workplace necessary to accommodate the worker. The obligations exist as long as there is an employment relationship. However, there are instances when the duty to maintain employment obligation ends, and I'll share that on my next slide. So generally speaking, the obligation ends on the second anniversary of the date of injury. However, the employer's obligations are not static, and their obligation changes to correspond with the worker's changing level of function. So in reviewing the table in front of you, by the second anniversary of the date of injury, if the worker is doing their pre-injury or alternative work, the employer's obligation to make changes to the work or workplace necessary to accommodate a worker is ongoing. By the second anniversary, if the worker is carrying out suitable work, the employer's obligation to offer the pre-injury or alternative work ends. However, their obligation to make changes to the work or workplace necessary to accommodate a worker is ongoing. And by the second anniversary, if the worker has not returned to work, the employer's obligation ends. And if the worker voluntarily ends the employment relationship, generally speaking, your obligation under the duty to maintain employment concludes. Now, these two duties carry with it also consequences of noncompliance, again, within the duty to cooperate and duty to maintain employment obligations. If an employer isn't taking steps to comply with their obligations or address an issue, we'll contact them to learn more, discuss the issues and potential barriers to cooperation, and offer our support. In rare cases, further escalation or penalties may be required as laid out in the legislation. If an employer remains non-compliant, WorkSafeBC may apply an administrative penalty based on the amount of the wage loss or other benefits being paid to the worker. In terms of the worker, the decision on whether a worker has failed to comply with their duty to cooperate and the consequences is completed by the claim owner. WorkSafeBC will adjudicate the worker's failure to comply with the duty to cooperate. If a breach has been determined, the worker may face a reduction or suspension of benefits. As with the previous duty, here's another question. If an external applicant is a stronger candidate for a job, do I have to give it to the worker? Again, if an external candidate is a stronger candidate for a job, do I have to give it to the injured worker? And the answer to that question is yes. If the injured worker is capable of performing the essential duties of the job, then it must be offered to them. Now, the key word on this question is external, and I will get to how that applies under collective agreements. And the next question, if there is no suitable work, am I required to create a position? Again, if there is no suitable work, am I required to create a new position? And the answer to that question is no. Employers are obligated to identify and offer work that is safe, productive, and consistent with the worker's functional abilities and skills, and if possible, restore the worker's wages. Generally, employers are not expected to create new job positions or roles simply to fulfill the obligation to offer suitable work. employers are expected to identify and make available suitable work opportunities that already exist or may exist within the organization and that match the worker's functional abilities and medical restrictions. As an employer, you should consider what changes to the work or workplace could be made to allow a worker to return to work. With regards to collective agreements, now that we have a better understanding of both the duty to cooperate and duty to maintain employment, and excuse me, I'm about to sneeze. Let's talk about section 154.4 of the Act and how these obligations impact collective agreements. Darn, allergies with spring. I do apologize. Return to work obligation. When there is a conflict between the new obligations and a collective agreement, the rule or provision that provides the most favorable return to work options for the worker will prevail, except where seniority is a factor. So seniority-based terms in a collective agreement are unaffected by the obligations to cooperate and maintain employment. So what does that mean? This means that there may be situations where an employer might not be able to offer suitable work to an injured worker because a more senior employee is entitled to that position, or where they may need to post a position that was initially offered to a less injured worker on a temporary basis. So now that we've covered briefly about collective agreements, what information can you ask? Well, in meeting obligations are both the duty to cooperate and duty to maintain employment, one important principle to keep in mind is to keep those lines of communication open. So what can be shared when someone sustains an occupational injury or illness? Well, the employer is allowed to access information that they require to operate their business. The information that can be disclosed to an employer about an injured worker includes only that which is medically necessary to determine the worker's return to work status. So for example, as you see on the slide, this can include a worker's functional abilities and restrictions, when the injured worker is expected to return to work, whether the injured worker will need temporary modified duties or suitable work when they return, their return to work hours, and recommended workplace accommodations or considerations to facilitate return to work. Now, a worker is not required to disclose details related to their diagnosis, to their treatment, or any other medical interventions. So what is our role here at WorkSafe BC? Well, firstly, we recognize the benefits of injured workers remaining connected to employment following a workplace injury or illness. The new legislation supports timely, suitable, and durable return to or continuation of work, which preserves or restores the employment relationship and reduces risk of joblessness. So essentially, we look for three things. Was there a work offer made? Was it safe, suitable, and productive? And if there was a refusal, was it unreasonable? So under the new legislation, the role of WorkSafe BC is to facilitate communication between the worker and employer, provide return to work planning, consultation, and support, and address any disputes around suitability of a return to work plan and reasonableness of refusal. We know that cooperation is paramount for successful return to work outcomes when we are notified of a breakdown in cooperation from either the worker or employer, and we have an obligation to be responsive. While the legislation allows for a maximum of 60 days to resolve disputes, these issues require a sense of urgency to preserve the employment relationship and restore communication focused on recovery and return to work. Our goal is to resolve these issues in days, not weeks. And finally, our role also includes determining employer and worker compliance with their obligations. So some key takeaways from today. Starting January 1st of this year, workers and employers have a legal duty to cooperate with each other and with WorkSafe BC in a worker's timely and safe return to work following an injury. And if an employer regularly employs 20 or more workers and has employed the injured worker for at least 1 year before their injury, the employer has an obligation to maintain that worker's employment up to the point of undue hardship. Finally, while there are financial consequences to both the worker and employer for non-compliance, our focus will be to encourage compliance through education, consultation, and support. And following that, if you do require any help, the team I belong to offers a variety of services and resources to help employers in meeting their obligations. And these resources can be found on WorkSafeBC.com. If you use the search term return to work, you'll have access to a number of resources available to you to help you with returning your injured worker to work. One such service that we offer is a virtual course teaching return to work for both return to work coordinators and frontline supervisors or managers. If you are interested in learning more or taking this free course that we offer, my contact information, I'll put that in the next couple of slides. Before I do, I just wanted to pay particular attention to some mental health resources that were just published a few weeks ago on our website, again, on WorkSafeBC.com. So we have the published as 2 mental health resources to assist you in navigating return to work for injuries for workers who are experiencing psychological injuries. So those are there for you to use as you see you need to. And as mentioned, here is my contact information. We have a number of resources. We have a virtual course. If you are interested, by all means, please feel free to get in touch with me. I'll leave this for just a few moments to jot down my contact before I go into the next slide. And finally, we also have a return to work program support line. So this line is answered by return to work specialists on my team. Here you can get answers and guidance in building your return to work program. Now, there is one particular note that I would like to make to you. This line is not meant for guidance or help on specific claims. If you need assistance with specific claim-related issues, your best contact will always be your claim owner. The line that is in front of you is meant to help as guidance and support to you in helping build your return to work program. So this ends my presentation on the duty to cooperate and duty to maintain employment. I do hope you found this session informative. Again, we have a number of resources available to you on WorkSafeBC.com. My contact is available to you. And if you have any questions, you can also feel free to get in touch with a specialist from our employer support line. Again, thank you for attending.
Perfect, Arvin. And if we can just, you can unshare and I'll share my screen.
Yeah, as soon as I figure out how to do that here on Zoom, I will do that. There it is, I think. Perfect. Am I unsharing now?
You are unsharing.
Oh, wonderful.
And I will reshare. There we go. So are we seeing? Are you seeing the question? Okay, perfect.
I see the question screening.
Perfect. Thank you so much, Arvin, for your presentation. So we have had a couple of questions come through. As a reminder, if you do have any questions and you haven't submitted them, you can pop it in the Q&A down at the bottom and we can get through as many questions as time allows. Before we get to those though, I want to thank you all so much for attending. When you leave the webinar, you'll be asked to complete a short feedback survey. So there will be 4 quick questions. And we'd really appreciate if you could fill those out. It helps us understand if these webinars are working for you. And I know Arvin had some information about contact for the return to work group at WorkSafe and his contact information. And as I mentioned earlier, this webinar is being recorded, so you will be able to get that information as well after the presentation if you didn't get it a couple of minutes ago. So Arvin, one of the questions that came in was around awareness when filing claims and what onus there is on unions, for example, of letting their members know what kind of claims can be submitted or when they should be submitting claims.
I'm not quite sure I understand. Like, I don't know if I understand the question clearly. So is there an obligation for the union to inform their members of when to file a claim?
Yeah, or even just around the duty to accommodate provisions.
As if an injured worker or if there's a worker who has been injured while performing the duties of their job, generally speaking, it is a good idea to file a claim. The worst that can happen is the claim just goes nowhere. It becomes a healthcare only claim. But at least to the sense that if a claim has been filed, if further entitlement to benefits are required, or if subsequently a worker does come off of work and needs access to wage loss benefits, that will be available to them. So generally speaking, it is a good idea for an injured worker to file a claim, whether or not they end up needing access to WorkSafe BC benefits down the line.
Okay, and when you say an injured worker too, I think some recognition around that is also around not just the injuries we typically think of, you know, if you've a sprain or perhaps a violent incident in the workplace, but also around those perhaps bullying and harassment, psychological injuries as well, to that slide that you spoke to just a little bit earlier.
Absolutely. Yes. So this is both physical and psychological injuries. If you feel that you have sustained an injury to either of those two systems, let's say, um, always a good idea to be on the safe side, file the paperwork, whether or not you are going to utilize the benefits or not, at least that paperwork is in.
Okay. There was another question. I'm not sure if you're able to answer this or not, but I can pose it to you. And if you can't, then we can certainly try and get the answer and respond back. How is lost time compensation calculated if a worker takes holidays during their claim?
Yeah, that is actually if someone takes holidays. So the determination we make when someone is on holidays, that is irrelevant when making our determination for wage loss benefits. When our determination is if somebody is entitled to receive wage loss payments and they continue to be temporarily disabled, we will continue to make those payments. If somebody subsequently is on holidays while they are in receipt of their wage loss benefits, they are still entitled to their wage loss benefits through WorkSafe BC. However, if an employer during that time they're on holidays has modified duties available that the worker or could have subsequently worked had they not been on vacation, then those wage loss determinations can be made by the claim owner as to whether or not those are payable during the time that that person is on holidays.
Right. And one other one we had, and this is around kind of the return to work and when you're getting some conflicting information. So a worker has been injured, they have sought out information from either, let's say, a physiotherapist or a physician, and they're getting a bit of conflicting information. So the physiotherapist is saying, you know, these are limitations, and the doctor on a doctor's note might say, you know, off work for 2 weeks, and that's it. And so how does the employer navigate that?
That's a fantastic question, Anna. Very often that is something that WorkSafe BC, when I was back in claims and working as a claim owner, we always had to get into the middle and be the liaison between the worker, the physiotherapist, and the physician. Now, as the employer, under this new landscape with Bill 41 legislation, the duty to cooperate and duty to maintain employment has one guiding principle in it. Essentially, it's communication. The best way to navigate that is to communicate with their injured worker and to ask them the question. It is simply to the conversation could go in the sense that, you know, Mr. Mrs. Worker, I see that we received this information from your physician. We received this other information from your physiotherapist. They seem to be telling me two different things. Can you help me reconcile what the difference is with the medical findings that I'm seeing in front of me so we can help and assist you in finding some suitable work for you at the work site.
Okay. We've had a question come in. Some of our members, our employers, they have locations outside of BC as well. And so are you able to speak to whether WorkSafe BC's regulatory expectations, as well as kind of the interaction between the collective agreements, are consistent with other jurisdictions across Canada?
I know there are some jurisdictions that also have similar types of legislation. How they apply their legislation within those particular provinces or jurisdictions, something I can't answer. I don't know too much about some of the practice directives that they've outlined to some of their staff, so it would be difficult for me to outline any other jurisdictions, but I do know that there are jurisdictions within Canada that have similar legislation as us.
Okay, I'm just kind of going through the chat just to see if we have anything else. We don't for now. If any questions come up, you'll see on the slide there, feel free to email us at training@safecarebc.ca, and we can certainly forward any questions to Arvin after the webinar. So if you do think of something after the webinar and you want to forward that to us, please feel free to do that. Just before we go, we do have some upcoming events. We have a couple of PVPC Train the Trainer courses coming up, and these are fantastic opportunities for our members to get people in-house trained on delivering the provincial violence prevention curriculum, the 8 hours. These are 4-day courses. We've got one coming up in Brants Creek Mews in Kelowna in June, and another one in Sydney on the island in August. So if you have anyone in your organization who you think might be a good fit for those courses, that would be great. Feel free to register. I do know that there are spaces in both of those. And you can see there, I think Zach, thank you, Zach, has popped in where to register for these courses online. Thank you very much, everyone, for attending today. We will be sending out a copy of the slides as well as a recording. And the other thing that I'll mention is that SafeCare BC does have an injury management toolkit on our website that can assist you in your return to work for your employees. And so that is freely available to download on the website, but we'll make sure that we pop a link in that to a follow-up email to you all as well. So thank you so much. Thank you, Arvin. Very informative. And I hope you all enjoy the rest of your day.
Thank you, Anna. It's been my pleasure.